All right, everyone, welcome to what we're now calling ACE, your RES exam. You're definitely here because you want to nail that RES
It's
exam,
a goal.
and we've absolutely got your back. Think of this as the ultimate study session. No fluff.
Laser focused.
Exactly.
Uh,
Focused on the essentials of strata living in Singapore. We're drawing heavily from the BCA's, the Building and Construction Authority's guide.
oh, yeah, the Strata living in Singapore, a general guide. It's pretty comprehensive.
It really is. It covers, well, everything. Share value, disputes.
The whole lot. Our job today is basically to pull out the absolute must-knows for your exam.
Right. And look, we know diving into this kind of stuff can feel a bit like, well, homework you didn't ask for.
A bit dry sometimes, maybe?
Yeah, potentially. But we're aiming to make this engaging, memorable even. Because knowing this isn't just for the exam, is it?
Not at all. This is real-world stuff you'll need when advising clients on strata properties. Big time.
Absolutely. So grab your metaphorical highlighter, maybe a coffee, and let's dive in.
Let's kick off with Chapter 1. Share value. It sounds technical, but it's fundamental.
Okay, share value. Break it down for us.
In essence, it's a subsidiary proprietors, that's the owner, their proportional share in the whole development, often shown as a fraction, like say 5 over 350.
So 5 parts out of a total of 350 for the whole estate.
Precisely. That 5 represents your unit slice of the pie.
And why should a future agent, sitting the RES exam, care about this number? Seems a bit abstract.
But it's not. It's the key to several really important things. First, it determines how much you pay in maintenance contributions.
Okay, money. That's important. What else?
It dictates your voting weight in the management corporation, the MC. More share value, more say.
Right, your voting power.
And third, it literally represents your share in the common property, the pool, the gym, the lift lobbies, all that stuff. That's straight from the Act, Section 62.
Got it. Maintenance, voting, ownership share, crucial stuff. So how is this number actually decided? Does the developer just pick one?
Not quite. The developer proposes the allocation to the Commissioner of Buildings, the COB.
Well,
And they usually bring in a professional surveyor to help figure it out. It's meant to be objective. Section 11 mentions that.
so there's a process. What's this underlying logic? What principle guides the allocation?
Generally, it boils down to the perceived usage of common facilities. The idea is the more you're likely to use, the slightly higher your share might be.
Okay. So my tiny studio probably has a lower share value than that huge penthouse.
That's usually the case, yes. For residential properties, they often use floor area groupings as a proxy for assumed occupancy and usage.
Is there a standard scale or something?
Yeah, the guide actually has a table. Like 50 square meters or less usually gets 5 share value units. Then it bumps up. 151 to 200 square meters might be 8. It increases for every 50 square meter bracket.
Okay, so size matters, at least in residential. What about mixed developments? Shops below, apartments above.
Good question. In those cases, they often apply different weight factors. A shop might use more central aircon or have more customer traffic through common areas.
Right, more wear and tear, potentially higher running costs.
Exactly. So commercial units often end up with a higher share value allocation, meaning they pay more in contributions.
Makes sense. Now, you mentioned stage developments earlier. What happens with share value when a project is built in phases?
In stage developments, the potential for share value adjustments in later stages has to be spelled out in the stage development contract right from the start.
So buyers know upfront there might be changes.
Yes, within prescribed limits, though. And importantly, the developer needs the COB's okay for the share values of all units, even future ones, before selling the first unit. The later stages are provisional initially.
Okay, so it's regulated. Now, the big question. Once everything's registered, you've got your strata title. Can you argue later that your share value is wrong and get it changed?
Generally, no. Once it's registered, it's pretty much fixed. That's Section 62 again. But there are very specific, limited exceptions, like a proven error in the registration, maybe fraud, or if units are formally subdivided or combined.
Or as part of that stage development contract we just talked about?
Precisely. Only within those defined circumstances. Otherwise, it's set.
Right. Share value locked in, mostly. Let's move to Chapter 2. The subsidiary proprietor, the SP.
That's the owner, right?
Correct. The SP is the person whose name is on the strata certificate of title. They've officially taken ownership.
And their number one job is?
Paying those maintenance contributions to the MC. It's non-negotiable. The Act gives the MC strong powers to recover unpaid fees. Section 40 says, as a debt, Section 43 even allows registering a charge on the property.
Ouch. So, pay up is the message. What other key duties does an SP have?
They're responsible for maintaining their own lot in good condition, and that includes exterior features like openable windows and any pipes serving only their unit.
So, I need to make sure my windows aren't about to fall out. Basically, yes. Section 9 is serious negligence leading to damage or injury, or even the potential for it, can mean fines, even jail time. Keep things maintained.
Yikes. Okay, noted. What about those dreaded water leaks between floors?
Ah, interfloor leaks, a classic. The guide says it's a joint responsibility. Upper and lower floor owners need to investigate and fix it together.
And who's usually presumed to be the source?
There's a legal presumption that the leak originates from the upper floor unit, unless the upper floor owner can prove otherwise.
Interesting presumption. Avoids finger pointing, maybe. What else is on the ESP's checklist?
Complying with notices from public authorities about maintaining your lot. If you ignore them, the MC can step in, do the work, and bill you. Section 30 covers that.
Okay.
And crucially, you must obey the bylaws, both the compulsory ones and the regulations and any extra ones the MC makes. They govern how you use your lot and the common property. Section 32.
Bylaws, the rules of engagement for condo living. We'll definitely circle back to those. What if an SP wants to do renovations, like big ones?
If the work increases the total gross floor area of the development, think roofing over a private enclosed space, PES, or adding a slab over a void.
Right, making the building physically bigger.
Then you need serious approval, a 90% resolution from the MC. That's Section 37. And you might need URA approval, too.
90%. Wow, that's a high bar. Okay, let's flip to the developer side. Chapter 3, Duties of the Developer. What are their key responsibilities early on?
Before they can even collect maintenance charges, they need written approval from the COB, Section 18.
Right.
And all money collected must go into a dedicated maintenance fund. No mixing it with their own operational funds.
So they can't use maintenance fees to fund the show flat catering.
Definitely not. They also have to contribute for units they haven't sold or handed over yet.
Even the unsold ones.
Yes, though they get a 3-month grace period from the TOPI date. And financial accountability is key: proper books, annual audits, and making those audited accounts available for purchasers to inspect. Section 17.
Transparency. Good. Now, when does the MC actually spring into existence?
It's automatic. Section 24 says the MC is constituted the moment the strata title plan is lodged and the application for titles is made. All the SPs instantly become members. It's a legal body.
Instant MC. But there's an initial period, right, before the owners take over fully.
Correct. That's the time between the MC being formed and the very first AGM. It can last up to 12 months, Section 2 says. During this time, the developer essentially is the council, Section 23.
So the developer runs the show initially. Are there things they can't do during this period?
Oh, yes. Quite a few restrictions without COB approval listed in Section 49. They can amend bylaws, grant easements, transfer common property, sign long-term contracts, borrow money, or appoint a managing agent for too long.
Lots of checks and balances.
Even permitted alterations to common property might need a special resolution then, Section 50.
So they can't make major decisions unilaterally. When does this initial period end?
With the first AGM, it must be held within 1 month after the initial period ends, or within 6 weeks if 10% of SPs request it. Proper notice and agenda are required.
And if the developer delays?
Any SP or mortgagee can ask the COB to step in and appoint someone to convene it. It has to happen.
No dragging their feet. What's on the agenda for that crucial first AGM?
Section 26 lists the key items. Electing the first council is top priority.
Right. Owners taking charge.
Setting the contributions for the management and sinking funds, reviewing the insurance the developer arranged, deciding on matters needing general meeting votes, appointing a managing agent and defining their duties, and finally, adopting those first audited accounts.
A packed first meeting. Okay, the owners are now in charge via the MC, Chapter 4, the Management Corporation. Their main role.
Simple. Control and management of the common property. It's about self-governance for the estate.
So they run the place. What about record keeping? Sounds important.
Hugely important. Section 48 mandates keeping accounting records and financials for 7 years. Notices, court orders, meeting minutes with all motions, correspondence, other docs, also 7 years generally.
Wow, 7 years. That's a long time.
And they must maintain the strata roll.
The strata roll. Like a resident directory.
It's much more than that. It's the official register. Section 46 says it includes share value per unit, SP name and address, mortgagee details, nominee info if applicable, mortgage changes if a mortgagee takes possession, and a service address in Singapore for everyone listed.
The definitive list of who's who and who owns what. Got it.
Yeah.
How does the MC actually operate day to day? Through the council elected at the AGM.
Exactly. The council is the executive body elected at each AGM. Up to 14 members, including any sub-MC reps, Section 53.
14 max.
From that council, they appoint the office bearers, chairman, secretary, treasurer, usually done at the first council meeting after the AGM, if not at the AGM itself, Section 55.
Who's eligible to stand for election to the council? Any owner.
You need to be 21, an SP or a nominated family member or company nominee. And critically, not be in arrears with your contributions. You need to be paid up at least 3 days before the election.
No arrears. Okay.
There are also nomination limits based on share value ownership, generally 1 nomination per lot. But owners with significant share value might nominate more, though it's capped to prevent total dominance. Section 53 again.
Fair enough. What do the office bearers actually do? Chairman?
The chairman presides over meetings, rules on motions. Interestingly, no casting vote in a tie.
Okay. Secretary. Sounds busy.
Very. Handles minutes, notices for MC and council meetings, maintains the Strata role, deals with document inspection requests, correspondence, convenes meetings, except the first AGM. All the admin, basically. Section 56.
And the treasurer. Money person.
Yep. Issues levy notices, handles receipts, banking, accounting, prepares financial certificates, keeps the financial records and statements.
Oh.
Section 57.
Given the money aspect, can someone be treasurer forever?
No, there's a limit. Generally a maximum of 2 consecutive terms. Section 55. Small MCs under 10 lots might get an exemption via consensus resolution, but usually it's 2 terms and out.
Promotes turnover. Are there decisions that council cannot make alone?
Where they need the owner's vote. Absolutely. Section 58 says they can't decide anything requiring a general meeting resolution, ordinary, special, 90%, etc. And the general body can restrict their powers further, according to Section 59. Big decisions need the owners.
So, ultimate power rests with the owners in general meetings. What about conflicts of interest for council members?
Strict rules there. Section 60. If a council member has an interest in an MC contract, they must declare it and cannot participate in discussions or vote on it, may even have to leave the room.
Essential for integrity.
And Section 61 imposes a general duty on all council members to act honestly and diligently.
Good government's basics.
Okay.
Chapter 5, meetings. We know AGMs happen annually within 15 months of the last one. Section 27, what's typically on the agenda?
Electing the council, adopting the previous year's financial statement, confirming the minutes of the last meeting, and any other motion submitted. Standard stuff for an annual review.
What if something urgent comes up between AGMs? That's an EOGM, right? Extraordinary general meeting.
Exactly. Any general meeting that isn't an AGM, the council can call one by majority vote, or owners holding 20% of share value or making up 25% of SPs can requisition one in writing. Section 27 and the first schedule cover this.
So owners can force a meeting if needed. How does an owner get their specific issue onto the agenda?
Simple. Any eligible voter can submit a motion in writing to the secretary. The secretary then must include it on the agenda for the next general meeting. First schedule, para 12.
Ensures individual voices can be heard. How are owners notified about these meetings?
Notices must state the place, day, hour, the exact wording of proposed resolutions, any other business, minutes of the last meeting, if not sent already, and voting rights info.
Comprehensive.
AGM notices also need the financial statements, auditor's report, and specific motions on adopting accounts and the managing agent. Notice periods. 14 days for ordinary resolutions, 21 days for all others. First schedule, para 1.
Plenty of time to prepare. What about quorum? How many people need to turn up?
For a general meeting, you need SBS present, in person or by proxy, holding at least 30% of the total share value.
30%? What if you don't reach that?
If there's no quorum after 30 minutes, the meeting can proceed with just 2 or more SPs present. But this doesn't apply if the meeting was requisitioned by the SPs themselves. They need to ensure turnout if they called it. First schedule, para 3.
Ah, interesting rule. Who actually gets to vote?
You can't owe the MC money. And you must be the SP or mortgagee in possession, the first mortgagee if the SP isn't voting, the senior joint owner, the first in line in a succession, a trustee SP, or an appointed proxy. First schedule, para 2.
So, clear eligibility. What about proxies if you can't attend? How does that work?
You appoint someone in writing. The proxy form and power of attorney, if used, must be lodged at the MC's address at least 48 hours before the meeting. No last-minute proxies. First schedule, para 17, 18. A company appoints under seal or by an authorized officer.
48 hours notice. Got it. What about council meetings? Can regular owners attend?
The council decides when to meet. The secretary posts notice with the agenda 3 days prior and gives it to council members. Second schedule, para 4.
And attendance.
SPs can generally attend as observers but can't speak unless the council agrees. Second schedule, para 5. It's more of the council's working session. Quorum is a simple majority of council members. Second schedule, para 2.
So, listen but don't talk, usually. How does voting work within the council?
1 vote per member, including the chairman. No casting vote for the chair. Majority wins. They can even vote in writing without a meeting if the agenda is circulated and a majority agrees in writing. Still needs to be minuted, though. Second schedule, para 7.
Written votes allowed, efficient.
Mm-hmm.
Are the minutes of council meetings shared?
Yes, transparency again. A copy must be displayed on the notice board within 7 days for at least 14 days. If no notice board, it's given to each SP. Second schedule, para 3.
Good to keep everyone informed. Okay, money talk again. Chapter 6, maintenance contributions. What do we pay these?
To maintain the common property and cover all the shared expenses, it funds the MC's work. Normally, it's proportional to your share value. Section 41.
And there are 2 types of funds, right?
Yes, the management fund and the sinking fund. Section 39 covers both.
Management fund. That's for everyday stuff.
Exactly. Day-to-day running costs, routine upkeep, insurance premiums, cleaning, security maybe, anything recurrent that isn't a big capital expense.
And the sinking fund for the big-ticket items.
Precisely. Future capital needs. Think major painting jobs, buying new pool furniture, replacing the lift system, major roof repairs, paying off large debts, other big capital works. Long-term planning, Section 39 again.
Management for now, sinking for later. What if someone falls behind on payments? We know the MC can chase the debt.
Yes, and interest applies after 30 days overdue at a rate set by the MC or general meeting. After 30 days, they can serve a written demand.
And if you still don't pay after the demand?
Failure to pay within 14 days of that demand is actually an offense, potentially leading to a fine. Plus, the MC can go to the small claims tribunal or courts or register that charge against the property, sections 40 and 43. Best to pay on time.
Definitely seems less hassle. Can the contribution method ever change from being based purely on share value?
Only with a consensus resolution. Every single SP has to agree in writing. Very rare, very difficult to achieve, but legally possible under Section 41.
Consensus needed. High bar. Can the MC offer discounts for early payment?
Yes, Section 41 allows rebates or incentives for prompt payment, but it requires a special resolution passed at a general meeting to implement such a scheme.
Special resolution for discounts.
Right.
Okay. Chapter 7, managing agents, MAs, what's their role?
They're the professionals the MC can hire to help run the estate. Section 66 allows appointment for up to 3 years with an annual performance review at the AGM.
How are they appointed or removed?
By ordinary resolution at a general meeting. Or the council can do it, but only if authorized by the owners at the last general meeting.
What powers can the MC give them?
A lot. The MC can delegate many of its powers and duties via ordinary resolution. Section 67. This can even include tasks usually done by the chairman, secretary, or treasurer, or effectively running things day to day.
Wow. Quite a bit of responsibility. Any limits?
Yes. MAs can't delegate powers further. They can't decide matters restricted to general meeting resolutions. And importantly, they are liable for BMSMA breaches as if they were the MC.
So they carry the can for mistakes.
And Section 68 specifically forbids them from canvassing for proxy votes in council elections. They need to remain neutral there.
Right. How can an MC be sure they're hiring a good MA?
There are independent accreditation schemes run by bodies like AMCIS, SISV, APFM. The guide recommends MCs consider accredited MAs for quality assurance.
Look for the stamp of approval. Makes
Right.
sense. Now, Chapter 8, bylaws. The rules for living together.
Exactly, designed for harmonious living. There are compulsory bylaws set out in the BMSMA regulations that everyone must follow.
And can the MC add their own rules?
Yes, they can make additional bylaws via special resolution as long as they don't conflict with the compulsory ones. That's Section 32.
Okay, what kind of things do the compulsory bylaws cover? Give us the highlights.
Oh, a whole range. Noise limits, proper parking, no obstructing common areas, no damaging plants. Alterations to common property usually need permission, though safety devices like extra locks might be okay under certain conditions.
Behavior, too.
Yes, appropriate behavior, dress code in common areas, no offensive language. Kids shouldn't cause damage or excessive noise. Owners are responsible for their visitors' behavior.
What about practical stuff like rubbish and laundry?
Yep, No dumping rubbish illegally. Laundry only in designated areas for reasonable times. Window cleaning responsibilities are defined usually SPs for openable ones, MC for others unless resolved otherwise.
Flammables. Pets.
Need permission to store flammable liquids beyond normal domestic use. Keeping animals is usually allowed, but they can't be a nuisance. Owners must maintain their own lot properly so it doesn't cause issues.
Using the lot. Fire safety.
Can't use your lot for anything illegal or that harms the estate's reputation. Need to notify the MC of change of use. And crucially, it must comply with fire safety rules, no obstructing fire exits or putting dangerous items on balconies' windows.
That's a comprehensive list. Seems like common sense mostly, but good to have it written down. Can the MC set rules for using facilities like the pool?
Yes, they can set operating hours and conditions via special resolution, Section 32 again.
And can they provide extra services like maybe better security and charge for it?
Yes, also via special resolution. The resolution needs to specify the service, the charges, and conditions.
Special resolution seems key for many operational rules. What if someone breaks a bylaw?
The MC or any affected owner or resident can apply to court for an order to stop the breach and potentially claim damages. Section 32 gives it teeth.
So there are real consequences. What are house rules? Are they different?
They're similar to bylaws, but usually apply before the MC is formed. Once the MC is up and running and formal bylaws are enacted, the bylaws take precedence. House rules are more temporary.
Got it. What about exclusive use bylaws, like getting your own parking spot?
Exactly. Section 33 allows the MC to grant an owner exclusive use of part of the common property. The required resolution depends on the duration.
How does that work?
Less than a year needs an ordinary resolution. 1 to 3 years needs a special resolution. More than 3 years needs a tough 90% resolution. Examples include renting out a kiosk space or designating specific parking lots.
Possible, but needs owner agreement. Okay, Chapter 9, insurance. What must the MC insure?
Section 70 mandates they insure the buildings against fire, lightning, explosion, and other specified risks under a damage policy.
Is that always required?
There's an out. If all SPs agree by consensus resolution, the MC can decide not to insure against certain risks, or even at all, though that seems risky.
Very risky. What else?
They also need any other legally required insurance, like workman's comp, and definitely public liability insurance for incidents on common property. Section 71 covers that. Protects against injury claims, etc.
So the building and common areas are covered. Can individual owners get their own insurance?
Absolutely. They're free to insure their own unit contents, renovations within their unit, or specific risks like falling window liability. It complements the MC's policy.
Good to know. Chapter 10. Resolutions. We've mentioned several types. They're how the MC makes decisions, right?
Exactly. It's the formal decision-making process, allowing owners to manage their estate. Different levels of importance require different levels of agreement. Remember the notice periods. 14 days for ordinary, 21 for others.
Let's quickly recap the types, from hardest to easiest, with examples.
Okay. Top tier. Resolution by consensus. Needs written agreement from 100% of SPs within 12 weeks after a meeting. Example, deciding not to have fire insurance.
Needs everyone. Tough.
Yeah.
Next.
Comprehensive resolution. Needs written agreement from SPs holding at least 90% of total share value, also within 12 weeks post-meeting. Example, changing to a 2-tier MC system.
Still very high agreement needed.
Unanimous resolution. At a general meeting, 100% of the votes actually cast must be in favor. Example, granting an easement for another estate's pipes to cross your land, everyone voting must agree.
Right. Slightly different from consensus. What about 90%?
90% resolution. At a general meeting, at least 90% of the share value of the votes cast must be in favor. Example, approving SP improvements that increase the building's gross floor area.
High threshold, but based on votes cast. Next level down.
Special resolution. Needs at least 75% of the share value of votes cast at a general meeting. Very common. Example, making additional bylaws.
75%. A significant majority. And the most common.
Ordinary resolution. Simple majority, more than 50% of the votes cast by those present and eligible at a general meeting. Example, appointing or terminating a managing agent.
Super useful summary. That table in the guide is key exam material, I bet. No. Disputes. Chapter 11. What's the first step?
The guide strongly emphasizes good neighborliness and compromise first. Talk to the other party. Try to resolve it amicably.
Always the best start, if talking fails.
Mediation. Get a neutral third party involved to help facilitate a resolution. Can use formal bodies listed in Chapter 14 or any agreed-upon person. It's voluntary and non-binding.
Mediation next. What if that doesn't work either?
Then you can refer the dispute to the Strata Titles Boards, the STB. It's a statutory body with lawyers and industry experts who arbitrate specific types of strata disputes.
Arbitration by the STB. Are their decisions final?
Generally, yes. They are legally binding. You can only appeal to the High Court on a point of law, not just because you disagree with the facts.
Okay. What kinds of disputes can the STB hear? Is it anything strata related?
No, only specific matters listed in the Act, sections 101 to 115. It includes things like disputes over costs of defect repairs, ordering the MC to hold a meeting, challenging meeting validity or resolutions, revoking discriminatory bylaws,
What else?
challenging invalid bylaws, disputes over interest rates on arrears, contribution amounts, adequacy of insurance, ordering the MC to make an insurance claim, SP applications for alterations, MA appointment termination issues, compelling the MC to provide info, ordering an owner to grant access for works, and disputes between main and sub-MCs.
Quite a specific list. So if your dispute isn't on that list,
Then you'd likely have to go through the regular court system.
got it. STB for specific strata issues, courts for others. Now, Chapter 12. Two-tier MC schemes. Sounds complex. What's the basic structure?
You have a main MC, Tier 1, overseeing the whole development, and then one or more sub-MCs, Tier 2, representing distinct groups within it.
Like residential versus commercial.
Exactly. Common in mixed-use developments or large estates with different types of housing. Section 77 outlines eligibility, needs significant differences in use or type.
What's limited common property or LCP?
That's part of the common property designated for the exclusive benefit and management of a specific sub-MC. Think of a pool just for the residential block in a mixed development. The sub-MC manages and funds the upkeep of its LCP. Its boundaries must be clearly shown on the strata plan.
How do they decide if a two-tier system is suitable?
Based on the development's design, user groups, types of common property. Needs clear boundaries for LCPs, each managed by one sub-MC. And the sub-MC needs enough member slots to be viable.
Makes sense. How are sub-MCs formed?
Legally formed upon registration of the strata title plan that demarcates the LCP. Developers can set it up in new projects. Existing developments can also convert, Section 76.
What can a sub-MC do? Does it have the same powers as the main MC?
Mostly yes, but only concerning its own LCP and the lots within its sub-MC. It has its own funds, budget, levies, bylaws for its area, can sue and be sued separately.
Or are things it can't do?
Yes, Section 79 lists limitations. Sub-MCs can't transfer common property, grant easements, approve major lot improvements, maintain the main strata role, ensure the whole building, or handle major structural defects. Those stay with the main MC.
So they have local control, but operate under the main MC's umbrella for big-picture items. How are sub-MCs represented on the main council?
Section 80 requires at least one executive committee member from each sub-MC to also be a member of the main MC council. Ensures communication and coordination.
Good linkage. How do contributions work for owners in a sub-MC? Do they pay twice?
Essentially, yes. They contribute to the main MC's funds for the overall common property, and they contribute separately to their own sub-MC's funds for the upkeep of their LCP.
Definitely more complex financially. Okay, nearly there. Chapter 13, Stage Development. Remind us what this is.
It's a project built in phases. The key is that potential changes in later stages must be disclosed upfront in the stage development contract, part of the sale and purchase agreement.
So buyers know what might change, like offices becoming retail.
Exactly. The contract must specify the range of potential share value changes too, and what happens if changes exceed that range. It also distinguishes between warranted development, what the developer must build, and authorized proposals, what they may build.
Warranted versus authorized. Clear distinction. What else is in that contract?
Type of development, warranted, authorized, description of each stage, statutory covenants, developer's liability for common property use during later construction, initial bylaws, and easements.
And if the plan changes later?
Amendments must be lodged with and accepted by the COB, and the developer must inform all SPs, purchasers, and mortgagees. Section 121 ensures this.
Transparency is key in long projects. Finally, at Chapter 14, getting information. Where does an owner go first?
Their own management corporation. Section 47 gives owners the right, for a fee, to get MA details, office bearer info, and inspect minutes, accounts, and other records.
MC first. What about external help or broader info?
The guide lists key agencies. BCA's Commissioner of Buildings for Maintenance Management Issues, Singapore Land Authority's Registrar of Titles for Title Plans, Strata Titles Boards for Dispute Arbitration,
Mediation bodies.
Singapore Mediation Center, Community Mediation Center, also the Retax Conciliation Panel for Developer Disputes, and SISV Mediation Center.
Info on MAs or developers.
AMCIS, APFM, SISV for MCMA info, READACE for developers generally, and S&P Corp sells copies of the BMSMA legislation itself.
A great list of resources, so help is available.
Absolutely. Knowing where to go is crucial.
Well, there you have it. That was quite the deep dive into strata living essentials, straight from the BCA guide. We covered a lot: share value, duties, MCs, meetings, money, MAs, rules, resolutions, disputes, the more complex two-tier and stage setups, and where to find info.
Hopefully it's all starting to click into place for the exam.
Definitely. Understanding these principles, SP duties, developer roles, MC functions, how contributions work, bylaws, resolutions, it's all fundamental for that RES exam.
Couldn't agree more. This stuff forms a big part of what you need to know.
We really hope this session helps solidify your understanding and gives you, a real edge in your prep. Do go back over your notes and maybe reread relevant parts of the actual guide.
Absolutely. Reinforcement is key.
And with that, truly, from both of us, the very, very best of luck for your upcoming RES exam.
Yeah, go ace it. You've put in the work.
You've got this. Good luck.